Good morning. Welcome to our 2025 Energy Matters webinar. My name is Denise Weirs. I'm the Director of Corporate Finance at the Alberta Securities Commission. This morning, you're going to hear from Craig Burns. Craig is the manager of our energy group here at the Alberta Securities Commission, and hear as well from members of his team in our Q&A section. This webinar follows on the Energy Matters report that was published in December. Craig and his team do a review of the disclosures that are required under National Instrument 51-101 by issuers engaged in oil and gas activities. And so the purpose of today's webinar and the report is principally to provide guidance on what they're seeing as a result of those reviews. In addition, over the last number of years, the team's also been expanding their reviews to look at disclosure in the broader energy sector and can provide guidance on some of the useful type tips on disclosure for renewable energy projects and things like that. So you'll hear from Craig as well on that. And the team has monitors what's happening just generally in the energy sector, trends in disclosure, trends in financings, and provides insights in that respect. This year, the report, the Energy Matters report, and this webinar won't touch on the sustainability disclosure reviews that we've been doing. We've decided this year to pull that out and do that as a separate publication in order that we can look at issuers beyond just the energy sector. So that's something we're hoping to do in the first part of 2025, so stay tuned for that. Unfortunately, we have identified that a number of issuers have pulled their reports this year, some citing the Competition Act amendments as their reason. So a bit more of a challenge in gathering that disclosure this year. Just a couple of things just wanted to mention. We are trying to build out resources for reporting issuers with respect to their disclosure generally, and are looking early in 2025 to put a number of videos up on our website in the Issuer Toolkit section. Craig will talk about some of the existing resources in the oil and gas disclosure area, but trying to provide just some resources more generally on continuous disclosure obligations, how to file an insider report, how to file an exempt distribution report. So keep an eye out for those. As I mentioned, those should be available by the end of the first quarter of 2025. So with that, I'm going to do the land acknowledgement, and I will turn it over to Craig to get us started here. The Alberta Securities Commission is the securities regulator for the entirety of the province of Alberta. And Alberta, of course, is the traditional and ancestral territory of many Indigenous people, including the Métis people, the Inuit, and those First Nations presently subject to Treaties 6, 7, and 8. And we'd like to acknowledge and respect the histories, languages, and cultures of all of those First Peoples of Canada who have lived and cared for the lands for generations. And we are grateful to them that their continued involvement enriches our community. Okay, so with that, I'm going to turn it over to Craig to get us started.
Great. Thank you very much, Denise. Welcome to our webinar here. As Denise said, I'm Craig Burns. Thank you so much for attending. So before we get started, I'd just like to let you know that, as Denise had mentioned, she talked about our Energy Matters reports. So most of the information that we're going to talk about today is from that report that's available at asc.ca. If you go to asc.ca, you will see an archive of our previous historical editions of this report, as well as the oil and gas review reports that we did previous to the Energy Matters reports. You'll also see our previous webinars archived on there. You will, in addition, see we have a couple of webinars that may be of some interest to you. We have a 51-101 for officers and directors up there for you, as well as a 51-101 for beginners. So please check those out. Today's event is pre-recorded, which is unusual for us. Actually, it's the first time we've done it. It's been done before previously in corporate finance, but not for the for this actual webinar. We've had some technical glitches previously, and so we decided to make the best use of everybody's time here and get the information across as efficiently as possible. We would pre-record. So what we've actually done here, so we're live. I'm speaking live. Denise is speaking live. We'll turn to the actual pre-recorded slides momentarily, and then we're going to have some Q&A sessions throughout. There's actually 4 interspersed after some key sections, and then there's going to be one wrap up, and we will be live for those. And for those, I'm going to be joined by Richard Bush, who is our senior energy analyst in the energy group. He is going to help with that in coordination with Stacey Rollestad, who is one of our senior evaluation engineers in the energy group. She's behind the scenes helping with the Q&A. So if you have questions, please drop them into Slido. And as usual with these, I always ask you to try to keep your questions really general. If you have anything that's really specific to your situation, your company, we are very happy to address that offline. So if you put something that's really specific and we don't think it's a great fit for this session, we will follow up based on the contact info that you enter into Slido. What else? We've got a couple of code words for CPD credits that are going to appear on the screen at 2 different times. And they will be for dropping into the webinar survey after the session. So just wanted to remind you of that. I think that is it. Let's get rolling here with the agenda. We'll go to the pre-recorded. Okay, so the first thing we'll do here is do a brief run through of our agenda. We're going to start with a short introduction similar to what we've done in the last few years. The intention is to introduce you to the Alberta Securities Commission, the Energy Group, what our focus is, what we do, and the regulatory framework that we exist within. Next, we'll move on to disclosure identified for improvement, where we're going to address 3 NI 51-101 disclosure concerns, followed by our first Q&A session. Then we're going to talk about our emerging energy-related disclosure concern today, which is helium well flow testing. We'll follow that by another Q&A session. If helium isn't of interest, please note that we will be discussing, or what we'll be discussing, is actually applicable to just about any substance from hydrocarbons to water. Next up, NI 51-101 disclosure insights, where we will present some findings attributed to data we've collected and analyzed. We'll follow this with another Q&A session. Next up is environmental considerations with respect to oil and gas reserves. Do some Q&A after that as well. And then we'll close out with the energy in the Alberta capital market section, where we'll again present some findings attributed to data that we've collected and analyzed with respect to energy-related categories of reporting issuers, their market capitalizations, as well as their capital raising activities. There'll be a closing Q&A session at the end, during which you're welcome to pose any questions that you may have from any of the preceding sections. So, next up, introduction to the Alberta Securities Commission. So, the Alberta Securities Commission administers Alberta securities laws. It's entrusted to foster a fair and efficient capital market and to protect investors. It's a member of the Canadian Securities Administrators, or the CSA. Its role is to improve, coordinate, and harmonize regulation. The Alberta Securities Commission is the CSA's lead oil and gas regulator. We have an all things energy focus. What that means is we look at everything from oil and gas, which includes exploration and production, midstream services, to helium and hydrogen, lithium from brines, carbon capture, utilization, and storage. We look at environmental sustainability, renewable hydrocarbons, and environmental liabilities with respect to energy. The Energy Group's goal is compliant disclosure. To achieve this, we conduct reviews. With these reviews, we incorporate disclosure and technical evaluations. We assess compliance with securities legislation. We also develop and maintain securities legislation and technical guidance. In addition, we communicate with capital market participants. Onto regulatory framework. With respect to oil and gas, we have National Instrument 51101, Standards of Disclosure for Oil and Gas Activities, which we refer to as NI 51101 throughout. So 51101 applies to reporting issuers engaged in oil and gas activities. If you want to learn more about what oil and gas activities means, you can see sections 1.1 and 1.3 of 51101. 51101 addresses general standards and specific annual requirements for disclosure for reporting issuers engaged in oil and gas activities. The technical standard for 51101, of course, is the Canadian Oil and Gas Evaluation Handbook, or the COGE Handbook. Continuing with our oil and gas regulatory framework, there are a number of forms that are related to 51101 that are required to be filed on CDAR+. These include the Statement of Reserves Data and Other Oil and Gas Information, or the F1, report on reserves data, contingent resources data, and prospective resources data by independent qualified reserves evaluator or auditor, which we refer to as the F2. This document, the execution of this document, affirms COGE Handbook compliance. And then we have the F3, which is the Report of Management Directors and Oil and Gas Disclosure. The execution and filing of this affirms the content and filing of the F1 and the F3, and the filing of the F2. We also have the companion policy, which is the standards of disclosure for oil and gas activities. We refer to that as the 51101 CP. We have a couple of staff notices which are of relevance today. One being 51324, which is the revised glossary to NI 51101, and 51327, which is revised guidance on oil and gas disclosure. Of course, as we mentioned previously, we have the COGE Handbook. We have some other materials that are relevant to the regulatory framework outside of oil and gas. This includes the Securities Act in Alberta. We have the Energy Matters Report, which I would like to draw your attention to. The most recent edition of this was published in December 2024. We have historical editions of this report, in addition to the previous report, which was the Oil and Gas Disclosure Review Report. The Oil and Gas Review Report. And those are available as well at asc.ca. There's also the Corporate Finance Disclosure Reports. Those can be found as well at asc.ca. Most recent version of which was published in December as well. We also have financial reporting bulletins. These are published by the Office of the Chief Accountant. Next section is disclosure identified for improvement. So through disclosure reviews, we assess if that disclosure is misleading, including by omission, whether it focuses on material information, or whether it otherwise complies with all disclosure requirements. These reviews incorporate disclosure and certain support material. They prioritize reporting issuers for which the ASC is the principal regulator, or the PR. They assess disclosure we assess disclosure where other jurisdictions are the PR. And we proactively assist on oil and gas matters, but we assist as requested in other energy-related matters. In this section, we cover energy-related disclosure for reporting issuers engaged in oil and gas activities and are subject to NI 51101. We also cover disclosure from reporting issuers engaged in other energy-related matters. Some of these reporting issuers may also be engaged in oil and gas activities. The topics we're going to cover today involve the terms gross and net regarding production and reserves, the disclosure of less than all required reserves in the F1, and the ceasing to be engaged in oil and gas activities. So to start off here, we're going to talk about 51101 related issues, and we're going to start off with the terms gross and net. So the concern here is incorrect or inadequate disclosure of gross and net production volumes and reserves estimates. So some disclosure uses gross and net incorrectly, doesn't clarify the meaning of the terms that they're using, and doesn't clarify whether the disclosure actually represents gross or net. Production and reserves ownership must be clear in disclosure. Gross and net are fundamentally associated with ownership. Reporting issuers must avoid implying incorrect ownership or causing confusion. Differences in magnitude between gross and net can be large, obviously. Some reporting issuers can have as low as 1 or 2% working interest, very small royalty interests. Net interests can be obviously up to 100%. So if you're not referencing whether your disclosure is referring to gross or net, the discrepancies can be quite large, and the disclosure can obviously be misleading. In some cases, that can be materially misleading. Next, we're going to talk about what these terms actually mean with respect to 51101. So we define the terms gross and net in Staff Notice 51324. So 51324 defines gross as in relation to a reporting issuer's interest in production or reserves, its company gross reserves, which are the reporting issuer's working interest, operating or non-operating, share before deduction of royalties and without including any royalty interests of the reporting issuer. In relation to wells, it's the total number of wells in which a reporting issuer has an interest. In relation to properties, it's the total area of properties in which a reporting issuer has an interest. So per paragraph A, gross is working interest share before royalties. You can also use the following terms to refer to gross as well. So there's company gross production, there's company gross reserves, gross production, and gross reserves. The key takeaway here is that when we talk about gross with respect to 51101, and we expect to see in your 51101 disclosure, is that your references to gross are for working interest, not gross lease. So 51324 defines net as in relation to a reporting issuer's interest in production or reserves, the reporting issuer's working interest, operating or non-operating, share after deduction of royalty obligations, plus the reporting issuer's royalty interest in production or reserves. In relation to a reporting issuer's interest in wells, the number of wells obtained by aggregating the reporting issuer's working interest in each of its gross wells. In relation to a reporting issuer's interest in property, the total area in which the reporting issuer has an interest multiplied by the working interest owned by the reporting issuer. Just make note here, before we go any further, with these terms, in the definitions, you'll see italicized words. These italicized words refer to words that are actually defined within either 51324 or the instrument itself. So if you would like to get a better understanding of what these terms mean, please see those. So per paragraph A, net, again, is the working interest share before royalties. It can also be referred to as company net production, company net reserves, net production, and net reserves. Key takeaways for this section. Disclosure must be balanced, accurate, relevant, and reliable. Specifically regarding production and reserves disclosure, ownership must be accurate. We must have clarity on whether the ownership is gross or net. We expect you to not prominently feature or draw attention to unowned production or reserves. And what we mean by that is if you're using examples, you're trying to draw attention to a basin, perhaps maybe basin-wide characteristics. In no way should you be inferring that the volumes of production or reserves estimates that you're referring to are owned by the company. As needed, clarify ownership and terminology via additional disclosure. Draw your attention to instruction 4, part 2 of the F1, where we talk a little bit more about disclosure within the F1 and the requirement for disclosing ownership interests. Next topic is the disclosure of less than all reserves in the F1. So the concern is reserves disclosure that is less than all that is required to be disclosed in the F1. So some disclosure accounts for less than all of a reporting issuer's reserves and the reserves data disclosure per part 2 of the F1. Now, this is perfectly reasonable for immaterial amounts. You do not need to make disclosure of anything that's not material. But we're going to talk today why you should be very, very careful about excluding any reserves from your F1, why this could be cause for concern from us.
It's often caused by reporting issuers not having all overriding royalty interests evaluated or audited by their independent qualified reserves evaluators or auditors. If this doesn't happen, what can often happen is we have unattributed reserves or reserves that could be attributed if they had have looked at it, and their exclusion from Part 2 disclosure. So there's certain requirements within Part 2 that we just referenced that requires the disclosure of reserves data and certain characteristics of reserves data. If you don't have those reserves evaluated or audited appropriately, they may end up being excluded. This is common with smaller reporting issuers, or more common, I should say, with smaller reporting issuers. But it is an issue that we have noted with reporting issuers that file long-form prospectuses. Those prospectuses require disclosure with respect to Part 2 of the annual filings, sorry, part 2 of the F1. So reasons for excluding certain reserves from the F1 include an unawareness that the disclosure is in fact required and the interests aren't considered material. So as we dive into this further, oil and gas royalties are oil and gas ownership interests per NI 51-101. This is a misconception amongst some that don't consider the royalty interests or ownership interests. A reporting issuer with oil and gas royalty interests is engaged in oil and gas activities, and NI 51 applies. So if all you have is oil and gas royalties, you are subject to 51-101. And if they're a reporting issuer's only oil and gas interests, it's likely that those royalty interests will be material. Material interests must be disclosed under Part 2 of the F1. Talk about oil and gas activities. What does that mean? So searching for a product type in its natural location, acquiring property rights or property for the purpose of exploring for or removing product types from their natural locations, any activity necessary to remove product types from their natural locations. This definition is found in section 1.1 of 51-101 if you would like to read it in its entirety. The term property was used in the definition of oil and gas activities. And this term is actually defined in 51-324. So property includes fee ownership or a lease, concession, agreement, permit, license, or other interests representing the right to extract oil or gas, subject to such terms as may be imposed by the conveyance of that interest. It also includes royalty interests, production payments payable in oil and gas, and other non-operating interests in properties operated by others. So it's clear here that we're talking about not just working interests. We talk about properties, and we talk about whether a reporting issuer is engaged in oil and gas activities. We're also talking about royalty interests. Included in royalty interests are overriding royalties, which of course I mentioned are often excluded. Or not often excluded, sorry, or sometimes excluded by certain reporting issuers. And in fact, if they are excluded, sometimes we won't see the appropriate annual filings included with the prospectus filings and the appropriate disclosure within those filings. Key takeaways here. Oil and gas activities includes ownership of properties, which includes royalties. A reporting issuer with an oil and gas royalty is engaged in oil and gas activities, and reporting issuers engaged in oil and gas activities are subject to NI 51-101. If reserves can be attributed to an overriding royalty or any royalty, in fact, and they're material, they're required to be disclosed under item 2.1 of the F1. Instruction 1 of Part 2 clarifies specific ownership interests to account for. This includes all reserves with a direct or indirect ownership, working, or royalty interest. Next up is the concept of ceasing to be engaged in oil and gas activities. Our concern here is inadequate or erroneous disclosure from reporting issuers that have ceased to be engaged in oil and gas activities. Examples of this include reporting issuer not filing the notice required by section 6.2 of NI 51-101, declaring it's no longer engaged in oil and gas activities, failure to file such notice within 10 days, material errors and deficiencies in the filed notice. These can include such things as absence of a date of execution and the required signatures. Also, signatures from individuals that don't satisfy the signing requirements. You can understand why that would be of particular importance to us. If we see a signature we don't recognize, it's not from an officer, the CEO, etc. We could be concerned whether this has been filed appropriately, filed in error, etc. Can also be missing or incorrect execution dates. So we may not actually know when you cease to be engaged in oil and gas activities if we don't see it dated appropriately. The filing of the notice when it shouldn't have been filed. We've actually had situations where reporting issuers have filed a notice seemingly, in very, very few cases, seemingly to avoid having to complete their annual filings, believe it or not. Failure to update other disclosure to reflect the change that the company is no longer engaged in oil and gas activities. So this can incorrectly imply an intent to remain engaged in oil and gas activities. So incorrect disclosure may be misleading, particularly if investors aren't properly informed that a reporting issuer's business has changed, or a reporting issuer remains engaged in oil and gas activities but has filed a notice in error. This often occurs with smaller reporting issuers for which the ASC isn't the principal regulator. And so this has been an issue with some of these really small companies that exist outside or prime regulated by other jurisdictions in Canada. And as I mentioned earlier, sometimes we see this as an effort to avoid filing, or it's reporting issuers that simply have just a royalty interest or some minor interest in a property. And that may be all that they have as an organization. And they, for whatever reason, will make some determination that this isn't important to investors. Therefore, they're not engaged in oil and gas activities, and therefore they don't have to do their oil and gas filings. Of course, that's incorrect. A reporting issuer that ceases to be engaged in oil and gas activities is required to file a notice in accordance with Form 51-101 F5, Notice of Ceasing to Engage in Oil and Gas Activities, which we refer to as the F5. Of course, this must be filed within 10 days. As we talked about earlier here with the definition of oil and gas activities, it's actually intentionally broad. If you think you're engaged in oil and gas activities, it's very likely that you are. And even if you think you may not be, if you have anything to do with the extraction, production, sale of oil and gas activities, there's a very, very good chance that you are going to be considered engaged in oil and gas activities. A reporting issuer without reserves that satisfies at least one of the following points is likely to be engaged in oil and gas activities and therefore subject to 51-101. So if they have resources other than reserves, which we refer to as ROTR, they have or seek direct or indirect ownership, working or royalty interests in any oil and gas property. So even if they don't currently have an ownership, if they're seeking an ownership, it's likely that we're going to consider that reporting issuer to be engaged in oil and gas activities. They're involved in the search for a product type in its natural location. They make or receive production payments, or they have an agreement with a foreign government or authority in which they participate in the operation of properties or otherwise serve as the producer of their reserves. Key takeaways. Reporting issuer will still be considered engaged in oil and gas activities if it sells its major properties but retains undeveloped oil and gas leases, sells its working interests, and retains an overriding royalty, even if it isn't receiving payments for those overriding royalties. Files an executed F5 in error. So if you file the F5 and you either knowingly or unknowingly shouldn't have filed it, done in error, you're still required, or you're still subject to 51-101 and therefore required to do your annual filings. The F5 must be executed by 4 individuals comprising chief executive officer, an officer other than the chief executive officer, and 2 directors. It must be correctly dated and filed within 10 days. Untimely filing may result in unclear business activities. We've had companies that have switched industries that haven't updated their disclosure. They've maintained, for example, information on their website, information in other locations that talks about their efforts to pursue oil and gas activities, producing reserves, etc. If we don't receive a filing on time, we don't see the updates to other disclosure, we may deem your disclosure to be misleading. If a reporting issuer files a properly executed F5 yet fails to update other disclosure, as I just mentioned, including forward-looking information to clarify that it's no longer engaged in oil and gas activities, its disclosure may be misleading. So as mentioned, websites, presentation, also draw your attention to such things as risk factors. If you have risk factors that are specific to oil and gas activities and you've changed your business, you filed an F5, this could cause confusion. People may wonder whether you really have exited oil and gas activities. Reporting issuers must maintain accurate and current information on CDAR Plus. This includes their NAICS code. So on CDAR Plus, the NAICS code will refer to what industry you are involved in. We will see reporting issuers still be associated with junior resources, oil and gas, etc. And they may have exited. But when you go to CDAR Plus, you see this notification under the NAICS code that they seemingly are involved in oil and gas when they're not. So it's very important that you update your CDAR profile and update your NAICS code. So next we'll move on to questions with respect to the 51101 disclosure issues that we have just reviewed.
Okay, so we'll turn now to our first Q&A section here. Just as a reminder, anybody who has any comments or questions, please use the Slido app on the right of your screen and drop them in there. And you won't be able to see anybody's questions or comments, but they will come to us, just so you know. That's how that works. Richard, have we got any questions?
Yeah. We do, actually. Good morning, everyone. Thanks for being with us today. Our first question, if a reporting issuer has filed an F5, is there a requirement for the issuer to provide notice of re-engaging in oil and gas activities?
Yeah, so that's an interesting question. So the answer is no, but I think this is probably a good opportunity to remind people sort of the rationale behind the F5 in the first place, and why it's very important to ensure your disclosure is up to date. And if you do keep your disclosure up to date, there's probably not a need for something like that that would let people know that you've become engaged in oil and gas activities after letting them know that you're not engaged in oil and gas activity. So you don't need to let them know in any other way other than keeping your disclosure up to date. Ensure your website, ensure your things like your NAICS code on CDAR Plus, ensuring that boilerplate information in places like news releases and corporate presentations, it's very, very clear what your business activities are. And if you do that, there's no need to go looking for a form similar to an F5 to let people know that you've actually formally become re-engaged. Keep your disclosure up to date. Yeah, anything else, Richard?
A couple more questions here.
Okay.
If our company has a few minor royalty interests in oil and gas assets, are we considered to be engaged in oil and gas activities, and are we obligated to commission a reserves evaluation?
So, okay, so presumably a company that only has royalties, that's all they have. I'm going to presume here that their entire focus as a reporting issuer is, I guess, that royalty interest. If they have a royalty interest in oil and gas property, and that's all they have, yes, they would be considered to be engaged in oil and gas activities. Even if they're not looking to acquire any working interests, if that's all they have is that royalty interest, yes, we would consider them to be engaged in oil and gas activities. And in fact, I would consider it to be clearly that would be a material thing for that issuer. And as a result, we would expect them to comply with in full with 51101. That would include undertaking their 51101 annual filings. And so, yes, I would point them to section 2.1 of 51101 that walks them through what the requirements are as a reporting issuer for their annual filings. And now, with that being said, they would, with respect to completing those filings, yes, they would need to have a reserves evaluation done. It presumably would be rather simple, but yes, they would be required to do that, engage independent qualified reserves evaluator have that royalty interest reviewed, or sorry, evaluated, and presumably we would have the assignment of reserves, and that would be disclosed in those annual filings.
Okay, and last one for this section. For gross wells reporting, are wells that you've gone penalty in considered a gross well, even if it will likely never pay out?
Sorry, can you just say that? Just
Yeah, I'll repeat that one. For gross wells reporting,
yeah,
are wells that you've gone penalty in considered a gross well, even if that well will likely never pay out?
yeah. I was trying to think here, like in what context are they thinking? Or are we talking? I mean, I guess I'm not really sure if they're saying like in terms of how many wells they have. Would you include that as a well? Yes. In terms of anything else, I'm not sure what the context would be, but yes, if you've participated in, if you have an ownership in a well, yeah, you have a working interest in that well, or you have a royalty interest in that well, yes, that would be considered a gross or an interest in a gross well, I guess, but I'm not really sure what the other circumstances would be. If the person asking the question has got any more details that would help me understand maybe what the context would be, I'd be very happy to, because presumably there's more information here that I could give them a much more complete answer. So if they want to follow up, or even contact us after this using our contact information on the website, or even actually within the presentation itself here, and we can have a chat.
Okay. I think that's all we've got for this section. And a reminder, at the end, we'll have just kind of a general Q&A. So any come in late for this section, we could just move them down to the end if we need to.
Okay, sure. Okay, so just as a reminder here with respect to the CPD credits, we have our first word, and that word is energy. And so please drop that into the survey that will be coming here at the conclusion of this webinar. So next we will move into the pre-recorded next section.
So next up, we're going to talk about emerging energy-related disclosure that's identified for improvement. We'll have a brief introduction here. So non-51 101 energy-related disclosure has been increasing in the last number of years. Our Energy Matter reports have covered associated disclosure prep for this information. We're going to talk about what we've done here in the last few years. And of course, as I mentioned earlier, these Energy Matters reports that can be found on our website, asc.ca, including the most recent one published in December. In 2021, we covered exploration, development, removal, and sale of helium, exploration and development of hydrogen and the production of hydrogen from feedstock, and the recovery of lithium from oil field brines, primarily for battery production. 2022, we updated our views on helium. I'd like to draw your attention to that 2022 Energy Matters report with respect to helium. So we went into great detail, refined our views. If you have any questions, concerns, or are interested at all in our thoughts on disclosure of helium and circumstances under which you may be required to do certain disclosure, please consult that report. We also talked about the manufacture and sale of renewable or green hydrocarbons in 2022 and geothermal energy. In 2023, the subject was renewable electrical generation and its sale. And this year in 2024, we talked about well flow tests that involve helium. So helium is a small but growing aspect of Canada's capital markets. We had 8 reporting issuers at the end of September 2024, 3 of which Alberta was the prime regulator. Over the last few years, we've identified some deficient helium well test disclosure. We haven't addressed this subject previously, and I'd say it's not just that we've identified deficient well test disclosure, sort of anticipating further future disclosure. So I want to just make it clear that we would like to get this information out there for those that are considering at some point maybe having to do helium well test disclosure. Helium typically occurs in relatively small quantities alongside other substances such as nitrogen, carbon dioxide, water, and hydrocarbons like natural gas. After processing of production, helium is separated, it's purified and sold. Reporting issuer may be engaged in oil and gas activities if it sells any hydrocarbons that are recovered during a well flow test. A reporting issuer engaged in oil and gas activities, as we previously discussed, is subject to NI 51-101. If such a reporting issuer produces helium from a property as a byproduct, it has specific NI 51-101 byproduct disclosure obligations. Those obligations include, and I just draw your attention to sections 5.4 and 5.5 of 51-101. And within the F1 itself, item 2.1 sub 3C. So what is a byproduct? So if you recover helium as a byproduct, you would be considered engaged in oil and gas activities if it is produced as a consequence of producing a product type. So by product type under 51-101, we mean such things as the various crude oils, bitumen, natural gas, etc. A reporting issuer not engaged in oil and gas activities generally isn't subject to NI 51-101. However, 51-101 provides a framework for identifying and disclosing material information. We strongly encourage the use of 51-101 requirements and principles appropriately adapted for helium if you were not engaged in oil and gas activities, but you were involved with the production and sale of helium. Again, please refer to the 2022 Energy Matters report for further information. So well flow tests are used to obtain information about reservoirs containing various liquids and gases. Section 3A of Staff Notice 51-327 covers oil and gas well flow test disclosure. However, it's adaptable for use with other substances, including helium. I would recommend that even if helium is not of interest to you, and perhaps oil and gas, surprisingly, isn't of interest to you, the information in there actually would be very applicable to disclosure of other substances recovered during well tests, whether that be carbon dioxide, nitrogen, water, etc. So Section 3A of 51-327 was drafted with hydrocarbons in mind. It was drafted prior to the widespread application of horizontal drilling and massive stimulation operations. So the information that follows should be very useful for well flow tests involving oil and gas as well. Bit of an update. So the following may be material for well flow test disclosure involving helium. And if this information is material, we would expect that it would be disclosed. Includes stratigraphic intervals, the test type, whether we're talking DSTs, production tests, etc., the duration of the test, the rates of flow, whether they're peak, average, and or stabilized. Expect that to be explained in the disclosure. The percentages of the various substances recovered and whether those are peak, average, and or stabilized as well. Flowing pressures associated with the test, whether stimulation has occurred, the type of stimulation, the proppant, load fluid, etc., the volumes and their status of recovery as necessary. The recovered fluid types and volumes, of course, accounting for any load fluid. Wouldn't want to see you accounting for load fluid, implying that it's actually recovered reservoir fluids. The sampling and measurement information that's pertinent. Other pressure data, such as shut-in measurements and their associated times, etc. Significant production or pressure declines associated with the test. If there's no pressure transient analysis or well test interpretation, cautionary statement that the data should be considered preliminary. A cautionary statement that the results aren't necessarily indicative of initial production rates, long-term performance, or of ultimate recovery. In addition, other disclosure may be necessary, including details about such things as sampling, measurement, procedures, equipment, distinguishing between field and laboratory testing, and elaborating on anything unique, unusual, or unexpected during the well flow test. Additionally, general principles relating to balanced, complete, and accurate disclosure focused on materiality applies. We assume prominently featured disclosure is material. Forward-looking information should have a reasonable basis. Disclose material risks and assumptions. And define and explain any technical terminology that's included in your disclosure. Next, we'll cover questions related to our emerging energy-related section.
Okay, so thanks. We are going to turn to our second Q&A. Have we got any questions?
Yeah, we do have one so far. We'll get to that one. If a company has helium and natural gas, how would they disclose the helium volumes in their annual filings if it isn't a product type, especially if the helium constitutes the majority of the value due to commodity prices?
Okay. So first and foremost, as we mentioned, the 2022 Energy Matters report goes into quite a bit of detail on this very topic and how you would proceed. And so it all comes down here. So I would just encourage you to go and please take a look at that because it's going to cover a lot more detail than I can cover in the time we have here. But the most important thing for you to do is first and foremost, is to determine whether or not you were engaged in oil and gas activities. Richard, they said that the helium is the majority. They're producing natural gas.
The value.
In terms of value.
Yeah.
They don't say whether they're selling the natural gas. Okay. So let's presume that you're not selling the natural gas. Let's just say you're flaring it, what have you. If you were not selling that natural gas, you would likely not be considered to be engaged in oil and gas activities. As a result, you would not be subject to the requirements of 51-101. But what we would encourage you to do is to follow 51-101 as it's a great template for ensuring that you prepare your disclosure in a manner that includes most of the material information that most people will be looking to see. If you are engaged in oil and gas activities, if you're selling that natural gas, even if it's a small amount, we would consider you to be engaged, and therefore you would be required to do your annual oil and gas filings, etc. In which case, for that, what we would suggest you do is you do your normal oil and gas filings as you would normally do. You get an evaluation done, and you include that helium information within the F1. It would be included subsequent to the normal oil and gas disclosure that you would include in terms of the volumes and the values under item 2.1 of the F1. And subsequent to that, you would include information specific to the helium. But this is really going to come down to that determination of whether or not you're engaged in oil and gas activities or not. So take a look at the 2022 Energy Matters report. Please let us know if we can be of any assistance because, as I said, there's a lot of additional information and stuff to consider here in order to give you a full and proper answer to your question.
That's all the questions we have for this section.
Okay, we will move into the next section.
So our next section is NI 51-101 Disclosure Insights. All information in this section is actually derived from a reporting issuer's disclosure that we have collected and analyzed. So we use data to make informed decisions on regulatory matters. As I said, information in this section is attributed to data from regulatory filings. It all pertains to reporting issuers for which the ASC is the principal regulator, and would encourage you to see the 2024 Energy Matters report for more information like this. This first graphic that we include here is the technical revisions for gross, proved, plus probable, or 2P reserves. This graphic is actually drawn directly from the 2024 Energy Matters report. And this is an accumulation of all of the technical revisions from all of our Alberta reporting issuers since 2014. And you can see the distribution of positive and negative technical revisions, positive being to the right of the vertical line, negative to the left. And what you can see here from about 2014 through to about 2018 was a reasonable distribution, positive and negative technical revisions. You can see, though, that as of about 2018, we started to get increasingly negative. And then by the time we got to 2021, it was all negative. So when we take all of the technical revisions and sum them up for all our reporting issuers that have been categorized based on size into seniors, intermediates, and juniors, we can see that we have moved to all technical revisions are negative the last 3 years. And so we cover in great detail the methodology behind not only how this particular graphic is created, but how we actually break the issuers out into categories in the Energy Matters reports. And we also go into great detail on how to conduct reserves reconciliations, of which the technical revisions are a category for disclosure with those reconciliations. And I would also mention here in this section and in the following sections, whenever you see a graphic, you'll see a footnote that references the figure number and the page number where you can actually find this graphic and additional information. And that's with respect to the 2024 Energy Matters report. So these technical revisions should balance over time. This graphic right here shows from 2014 to 2023, the technical revisions that we saw on the previous slide it's essentially the number of positive and technical revisions over those years. And as these lines converge, we are seeing more of a balance. As they diverge, we are moving away from that balance. And you can see right here, as of about 2020, we really started to diverge. It looks like here in 2023, we may be kind of coming back to converging. So I would say that since 2021 in particular, the pattern of technical revisions has been quite worrisome. It may be turning around. This slide shows a number of time slices, technical revisions for those gross 2P reserves. So we did them 3 years apart from 2016 to 2022. We decided to include 2023 here as well, just to show what's happened since last year. And every single reporting issuer is represented here by a colored dot in the particular year. And what you would like to see is pretty even distribution or even number of green dots and red dots. You can see in 2016, we had more dots that were green, representing more positive technical revisions. By 2019, we had a pretty even distribution, but you could see that by 2022, we had really had far more negative technical revisions represented by the red dots than positive technical revisions. As well, the green dots were really clustered. The red dots were spreading vertically, and you could see them being more dispersed, representing the extent of those technical revisions. So numerically, the percentage of those technical revisions was increasing. By 2023, we've seen actually some increase in the number of positive technical revisions, but the negative technical revisions are still a concern, and you can see the distribution of those vertically, showing the magnitude of them being of concern. So the hope is that this sort of explains the technical revisions issue a little bit more clearly. As I said, each dot represents the 2P technical revision for a single reporting issuer. The placement of each reporting issuer's dot, though, changes year over year. So there's no way to actually track an individual reporting issuer through each of these time slices. We continue to plan to spend, we plan to continue to spend time reviewing the reserves reconciliations, asking questions to try to reduce the number and frequency of the negative technical revisions. This figure here represents the average allocation of gross proved and probable reserves for our reporting issuers. And so you can see here the proved reserves are represented by the dark blue. That teal color represents the probable reserves. You can see over time how these fluctuate. I just thought that this would be a good graphic to show you, in general, the differences between the groups of issuers, whether they be seniors, intermediates, or juniors, and how these different groups overall have their reserves booked. And what you're going to see here is that we tend to have more approved reserves booked for the seniors and the intermediates relative to the juniors, who tend to have more probable. In 2023, you can see the statistics here on the right-hand side, if that's of interest to you. This slide here shows the average allocation of gross proved reserves. The same reporting issuers that were grouped from the previous slide are shown on here, but now we've actually taken those proved reserves and broke them out into their individual categories. So we've got proved developed producing, proved developed non-producing, and proved undeveloped. The proved developed producing represented by this teal color, and the proved undeveloped represented by the orange. And again, we've got the 2023 statistics here on the right-hand side. One thing you'll notice here is that the seniors and the intermediates are pretty consistent with their relative percentages of proved developed producing and proved undeveloped. You'll see an increase in the proved developed non-producing for the intermediates over the seniors. And then as you get to the juniors, that proved developed non-producing dark blue actually increases substantially. And you see that decrease in proved developed producing. This chart here shows the gross proved developed producing, or the PDP, to 2P reserves distribution. As for the colors, so the seniors are here in orange. That teal color represents the intermediates, and the blue represents the juniors. The average here is about 32% for the seniors to 29% for the juniors. Most of these cluster somewhere between the 20 and 40%. This next graphic is the gross proved undeveloped to 2P reserves distribution. Same colors here as the previous slide applied. The average for the seniors is 32%, drops down to 20% for the juniors. And most of these companies are somewhere in that 20 to 40% range. I think these last two slides here should provide a little bit more color here and are supportive of what we showed in those previous two slides here that showed the breakdown in the proved and probable and the proved reserves. So this next slide represents the summed and average gross 2P reserves for our reporting issuers in Alberta. Represents we have the total reserves attributed to all of these reporting issuers shown here, broken out into seniors, intermediates, and juniors. And you can see how they ebb and flow over time. We've also got the average reserves for all of our reporting issuers combined, shown here as well on the right-hand side. So in 2023, in 2023, all of our seniors combined had 2P reserves just over 53 billion BOEs. The juniors had just over 1 billion BOEs. The average reserves in 2023 for all of our reporting issuers was just under 700 million BOEs. So this next slide represents the summed and average production for our reporting issuers. And you can see here that these colors actually are the same as we were in the previous slide. Seniors represented by the orange, the intermediates, that teal, and the dark blue, the juniors. So this represents the total production for the reporting issuers. We have grouped them by into that senior, intermediate, and junior. And we also have here the average production per Alberta reporting issuer as well. And just want to make it very clear from this slide and the previous slide, whether it's the reserves or the production, this is reflecting reserves and production from Canada and beyond. So regardless of where in the world it'd show here, That's why you see, for example, the production seems to be a lot higher than you would expect to see for production from Alberta or even Canada. And that is because these reporting issuers produce beyond Canada. So in 2023, the all seniors produced per day almost 6 million BOEs, and the juniors just over 83,000, almost 84,000 BOEs per day. The average production per reporting issuer was just over 82,000 BOEs. Next, we'll move into the Q&A section for the 51-101 Disclosure Insights.
Okay, so we'll, I guess, turn to questions here again. Richard, have we got any questions in this section?
Yeah, one question came in, and it's how are the companies grouped? How are they grouped in senior, intermediate, and junior? How do we get to that spot, I guess?
Okay, so our report, Energy Matters report, actually, in that particular section with respect to 51-101 Disclosure Insights, we actually provide an explanation in there that goes into a fair bit of detail, but I'll just kind of hit the highlights. So we break it up by production, with the seniors being reporting issuers that are in excess of 100,000 BOEs per day. And then from below 100,000 to 10,000 is the intermediates. And then below 10,000 is the juniors. That's how we've been doing it now since, I guess it would be 2015. Just maybe a little bit of color on the rationale behind it. We had noticed when we first started looking for, when Richard and I were going back to 2015, when we were envisioning trying to talk about some of the data that we had collected, we were looking for different trends and different things that we were seeing amongst the issuers. And we had decided that the best way to sort of portray some of these trends was to try to find a way to break these issuers up. It was as simple as that, deciding on those increments, those production increments. It's not any more complicated than that. And there's probably many other ways that you could do it, and everybody sort of has their preference in terms of how what they consider a senior or a junior, et cetera. And that's how we did it, and we've been sticking with it, because if we decided to change it now, it would sort of render a lot of that historical data to be not easily usable.
So we don't have any more for this section, but just a reminder, we did have some come in later for previous sections, so we'll throw those down to the bottom when we do the general Q&A wrap up. I'll get to those then.
That's a good point. Okay. Thanks, Richard.
So our next section is environmental considerations for oil and gas reserves. So briefly, all environmental considerations must be accounted for in disclosed oil and gas reserves estimates. And also, reserves and resources other than reserves must be disclosed using the applicable terminology and categories set out in the Kogi Handbook and classified in the most specific category that they can be classified. So just a little bit here on the rationale for this section. We've had a number of questions over the years from investors and even reporting issuers that have asked about whether certain things are considered when reserves are evaluated and when reserves are attributed. And we thought it would be a good idea here to talk about what is considered and with respect to environmental considerations. And we think it's very, very important just to try to maintain the integrity of the system, that people don't lose confidence and think that certain things aren't considered, and that reserves, perhaps they can't trust certain issuers' reserves or reserves overall because maybe certain things have not been accounted for. And as we'll see, that's not the case. So commercial status differentiates resource categories. By resource category, we mean such things as reserves, contingent resources, prospective resources, etc. Commerciality is effectively a measure of risk. Reserves are commercial. There's effectively no risk. Resources other than reserves are subcommercial. There's measurable risk from contingencies. And those contingencies need to be removed in order for reserves to be attributed. And when we talk about resources other than reserves in this section, we're primarily referring to contingent resources, and prospective resources. So we're going to next review the definition of commercial. When a project is commercial, it implies that the essential social, environmental, and economic conditions are met. And I've underlined environmental here for emphasis, including political, legal, regulatory, and contractual conditions. Considerations with regard to determining commerciality include economic viability of the related development project, a reasonable expectation that there will be a market for the expected sales quantities of production required to justify development, evidence that the necessary production and transportation facilities were available or can be made available, evidence that legal, contractual, and again, environmental, governmental, and other social and economic concerns will allow for the actual implementation of the recovery project being evaluated. Also, there must be a reasonable expectation that all required internal and external approvals will be forthcoming, and evidence to support a reasonable timetable for development. So we've truncated these last two considerations. If you would like to read these in more detail, please see CSA Staff Notice 51-324, where this definition can be found. So chance of commerciality, or CC, is a product of chance of discovery and chance of development. And also chance of commerciality is defined in 51-324, if you'd like to take a look at that. So with respect to chance of commerciality and certain specific resource categories. So with respect to reserves are discovered, the chance of development is effectively 100%. So because they're discovered and chance of development is effectively 100%, the chance of commerciality is effectively 100%. For contingent resources, well, they're discovered and the chance of development is less than 100%, so chance of commerciality will be less than 100%. But it can approach 100%. For prospective resources, it's a different story. They're undiscovered, so the chance of discovery will be less than 100%, and chance of development will be less than 100%. So chance of commerciality consequently is less than 100%. If commerciality considerations can't be satisfied, chance of commerciality is less than 100%. Reserves can't be attributed in situations where chance of commerciality is less than 100%. If reserves were previously attributed, they must be removed. Next, we're going to talk about some examples of environmental considerations that are specifically cited within the definition of commerciality. Specific environmental considerations will vary by project, and they can change over time. They include such things as GHG emissions and mitigation, water requirements, availability of water, its usage, management and protection, environmentally sensitive areas, wildlife migration routes, etc., biodiversity, species at risk, and habitat preservation. Soil conservation, energy usage, and lastly here, abandonment, reclamation of wells, facilities, properties, etc. So obviously there can be others. It's up to each reporting issuer to determine what environmental considerations should be taken into account with respect to their assets. And that should also be obviously discussed with their independent qualified reserves evaluator and auditor. Next, we'll address any questions that there may be with respect to environmental considerations for oil and gas reserves.
Okay, welcome back everybody to our next Q&A session. Richard, we got
a couple questions come in here. First, if a company is in possession of risked rotor, is it appropriate to only disclose the unrisked numbers?
Okay, so there's going to be, again, as with all of our, I guess, all questions, there's a whole bunch of different considerations. Without knowing whether the question involves disclosure in the annual filing or disclosure in outside of the annual filing, I guess we'll have to touch on both of those scenarios. So if it's for disclosure, rotor disclosure that is included in your annual filing, per Part 7, you're required to disclose the risked adjusted volumes and values. So, you would presumably, I guess I'm assuming here that this is probably for disclosure outside of it, but maybe that's a good reminder. So all your disclosure and per the F1 under Part 7 has to be risk adjusted. So you would have to disclose that information there. So for outside, you would be relying on Section 5.9 of 51-101 itself with respect to disclosure of rotor. And that it's requires you to disclose the risks and uncertainties. And the companion policy references the fact that the disclosure must be clear and allow an investor to properly understand what those risks and uncertainties are, and be able to theoretically derive what the quantitative impact would be of those risks and uncertainties on those volumes and values, or I should say values if you disclose them outside of the F1. You may just be disclosing volumes, but so I would find it hard to understand how you would be able to provide enough qualitative disclosure to enable somebody to arrive at what those risk adjusted numbers would be outside of the annual filing. If you actually have the risk numbers, and I would sort of caution you that if you have those numbers and you don't disclose them because you think your disclosure is adequate, you better be very, very careful. We've seen a couple of situations where companies have had risk adjusted numbers. They haven't provided them. The disclosure has been insufficient. We've asked questions. It turns out they actually have an evaluation with the risk adjusted numbers. And the conclusion we would draw from looking at the evaluation, the information in there is very different than what the information is or was in their disclosure. So that can present a serious issue for a company that chooses not to disclose information that they actually have. And they're relying on the qualitative discussion under 5.9. I hope that helps.
Okay, last one. Is the timing of development a consideration for commerciality when attributing reserves?
Yes. Short answer is yes. If you look at the definition of commerciality, it is, I believe, the last consideration is development timing. And so you have to consider the timing. And of course, won't go into the detail here about what the Kogi handbook says about development timing. But yes, if you are not intending to develop them within the timelines outlined in the Kogi handbook, you would be we would not consider the situation to be amenable to attribute reserves. So just be very careful with that. I guess keep it maybe that simple, but Kogi handbook obviously goes into more detail on that development timing.
And that's all the questions we have for this section.
Okay, so we'll go back to the webinar, the last section.
So our next section is energy in the Alberta capital market. Most of the information in this section is attributed to data from regulatory filings. Some of it is drawn from market data sources. All of it pertains to reporting issuers, for which the ASC is the principal regulator. We focus on the categorization of reporting issuers in this section, the market categories, capitalizations of these categories, and the financing activities of these categories. And of course, a lot more information can be found in the 2024 Energy Matters report. We start with information concerning reporting issuer categorization and the number of reporting issuers in each of those categories. So this first slide is number of reporting issuers by industry. Out of the 460 Alberta reporting issuers that are principally regulated by the ASC, 186 or 40% of these are attributed to the energy industry, as we categorize them here. And again, each of these figures comes with a footnote that you can use to find the particular image in our 2024 Energy Matters report. Next up, the number of energy-related reporting issuers. So what we've done is we've gone through all these reporting issuers that we regulate to determine if we think a reporting issuer is energy-related. In some cases, it may not actually be obvious from the name of the company. We look at the assets, we look at what their activities are, we make some determinations. So we have 197 reporting issuers that are involved in energy-related endeavors, which represents 43% of all Alberta reporting issuers that are principally regulated by the ASC. Next, we've categorized these into energy-related sub-industries, depending on, we have been able to determine by looking at their disclosure. So these range in categories from helium to lithium, utilities, oil and gas midstream, oil and gas services, etc. This next slide shows a number of energy-related reporting issuers by sub-industry from the last slide, but over time. And just pay particular attention here to the colors. They are different than what was represented by these colors in the previous slide. So 2021 is represented by orange. And through 2024 here, you can see the different colors. 2024 year to date is represented by this red. Year to date is actually September 30th. And you'll see later on in select cases, we've actually provided some more recent information that takes these, provides information up to actually the year end. And we've used call out boxes in some of these slides to actually show what transpired between the end of September and end of December. So as you can see from this, in terms of the numbers of reporting issuers engaged in oil and gas activities dominate our reporting issuers. And obviously fewer of all the other categories from services through midstream, lithium, helium, etc. So just zooming in here on the reporting issuers engaged in oil and gas activities, we, instead of just showing 2021 to 2024 here, we show it from 2012 onwards. And you can see that there has been a precipitous decline from 302 in 2012 to 114 at the end of September. It looks though like this number has been stabilizing in recent years. When we break those reporting issuers up into categories based on size, seniors, intermediates, and juniors, you can see here that obviously the juniors represent the largest reduction in reporting issuers over that time frame. So there's been a 69% decline since 2014. What we actually see here is that we've seen an increase in the number of seniors as we've had these some intermediates that have grown into that. We've had a few juniors grow into being intermediates as well, but what we haven't seen is this replenishment of juniors. So as we've lost juniors, we haven't had very many juniors enter, and as a result, that primarily accounts for this decrease over these years in the numbers of reporting issuers. Next, we'll turn to market capitalization of reporting issuers. So 64% of the market capitalization of Alberta reporting issuers is attributed to the energy industry. 64% is attributed to the energy-related reporting issuers, and you will see that it's 64% in the last two slides here. So the market capitalization of if we go back here from the energy industry to energy-related reporting issuers, because there are some energy-related reporting issuers that are not considered to be part of the energy industry, as most would understand it. They add a very small amount of market cap. So we're thinking here of the helium, the lithium, etc. Very, very small market cap. So it's not a measurable contribution when we look at from an energy-related perspective. 59% of the market cap is attributed to oil and gas-related sub-industries. So you can see on this chart here, we've got oil and gas related sub-industries, which includes oil and gas activities, oil and gas midstream, and services. Oil and gas activities, of course, dominates. Draw your attention to that. And you can see here how the market caps have fluctuated over time. We can see that the market caps for the reporting issuers engaged in oil and gas activities is actually growing from 2021 to 2024. Similarly, for oil and gas services for midstream, we've seen a little bit of a dip here saw a little bit of a dip in 2024. And lithium, helium, and other, you can see they actually don't even we have numbers representing the market caps, but they actually don't show here based on the scale. In terms of the market cap for average reporting issuers within each of these industry categories, the oil and gas midstream reporting issuers, they dominate. So the market cap for those issuers is much higher than it is for the individual reporting issuer engaged in oil and gas activities or issuer involved in services, utilities, etc. The average market cap of reporting issuers engaged in oil and gas activities over time has declined. So we talked about the market cap overall, how it's kind of increased, but the average market cap has actually declined here from 2021 through 2024. But that is just a very limited amount of time, but there has been a modest decline. So we see that from the seniors, the intermediates, as well as the juniors. Next, we're going to turn our attention to capital raising activity. So this slide represents the capital raised via prospectus by reporting issuers engaged in oil and gas activities. You can see here from 2016 to 2024 year to date, there has been an overall decline in the amount of capital raised via prospectus, as well as in the number of offerings. In this case, in this particular slide here, we actually were able to obtain data from the end of September to the end of December to sort of show what has actually transpired for the remainder of 2024. And so for the remainder of 2024, we did see an actual increase in the number of offerings. So we actually ended the year at 8 offerings with 754 million raised. So a little bit better than what was shown here at 2024 year to date. When we look at actually what was raised in each of these years, you can see overall it's mostly debt represented by that teal color that's been raised by our reporting issuers since 2016. In 2024, the total that 754 million that we showed on that, or we talked about just previously, that was actually all equity in 2024. There was 0 debt. This slide represents the capital raised in the exempt market, so raised via prospectus exemption by reporting issuers engaged in oil and gas activities. So this doesn't actually reflect companies that are not reporting issuers. So this is just strictly reporting issuers that have raised capital in the exempt market. So there, again, has been an overall decline since 2016 in the total amounts raised, as well as the number of offerings. And when we look at September, here we've been able to, from September to the end of the year, we've supplemented that information here. And as you can see, there was just over 6 billion raised in the exempt market in 2024. So almost double what was actually shown here at year to date. And we ended the year with 42 offerings. This chart is a comparison of the capital raised by reporting issuers engaged in oil and gas activities, reflecting the amounts raised via prospectus and raised in the exempt market. So those two previous slides combined, just so you can see, relatively speaking, what's been happening. So overall, there's more offerings, but less raised in the exempt market. This slide covers the capital raised via prospectus by reporting issuers involved in oil and gas services and midstream. So midstream represented by the teal, and services represented by the dark blue. And what you can see overall is that there's been a decline in the amount of capital raised and the number of offerings for both oil and gas midstream and oil and gas services. It's more pronounced, though, for oil and gas midstream, that decline. We've also shown the 2024 total numbers on here. You can see that in 2024, there was almost $6 billion raised by oil and gas midstream reporting issuers via 14 offerings. For services, it was $250 million from one offering. And this last slide shows capital raised via prospectus by reporting issuers and other sub-industries. So these are other energy sub-industries. And on here, we show utilities in orange, lithium in teal, helium in red, and then we also have other represented by that black color. So as you probably would expect, the utilities dominate. There's been minimal activity for others. Most of the capital raised for utilities by utilities reporting issuers has been debt. Most of that capital here in 2024, rounded up to the full year, was actually $1.5 billion from 5 offerings. And we've just a note here that we didn't see anything in 2024 for reporting issuers involved in lithium, helium, and other energy-related sub-industries. We had a bit of a bright spot there in 2023, but nothing in 2024. And most of that capital raised for lithium and helium. In fact, I think all of it was actually equity capital. And that concludes our energy in the Alberta capital market section. We will next move into a concluding Q&A section.
Okay, so we'll now conduct our last wrap-up Q&A. If we got any questions, Richard?
Yeah, we have a few questions to address here. So the first one, is there an initial timeline requirement or periodic requirement to have an update to the independent reserve report?
Okay. Well, there's a requirement for the annual filings. So a company engaged in oil and gas activities has got to do its annual filings, and this is where it's going to get a little bit tricky. It's going to come down to whether you have whether an issuer believes it would have reserves or to disclose if it did have an evaluation prepared. So I'm assuming if a company had an evaluation and there was reserves in it, and they're just wondering, do they have to actually have that done again at some point in time? So if the company still believes that it has reserves, yes, it would need to get an evaluation done by an independent qualified reserves evaluator for its following close of its financial year end.
Okay, next question. There was an AIF for a producer that disclosed gross production in 2 line items, one for production and one flagged as sales. Is this considered unusual?
So with this one's well, as I guess all our questions are a little tricky, because I wouldn't be sure if they've included any discussion or description of how they're using the term gross. But if we presume that they're using gross, as we've discussed here today, that it's working interest share before royalties. If that's what they're doing, and then they're also providing sales, I'm not sure. Sorry, is that sales numbers specified as being anything other than just?
It says the line item was flagged as sales.
Just sales.
Yeah.
Yeah, that's an odd one. I'd really have to take a look at it to see what the context of this is. But can a company disclose? I mean, if we go back to first principles 51-101, so all your disclosure has to be done at first point of sale, and it has to be done by product type. And we're going to assume that you're only going to be disclosing your working interest, and whether it's gross or net, you're going to specify. I'm going to guess that number, that sales number, is probably meant to be, a net That's probably I would assume that that's what they mean by it. I'd have to take a close look at it to see if that's actually what that is. Otherwise, it'd be very, very hard for me to say whether they've done that disclosure appropriately. But in reality, your disclosure, as I said, is supposed to be at the first point of sale. Anything that, if you provide any kind of disclosure that's not at your first point of sale, we would expect a pretty elaborate discussion as to what the disclosure is, why you're doing it that way, why you feel it's necessary to provide that disclosure in that manner. And if you're going to be using net and gross in any way that's different than those terms are defined in CSA 324, we would expect an explanation and be very cautious, I guess, in terms of how you use those terms in any other manner. I guess that's the best I can say without any further information on that.
Okay. And lastly, will the slide deck be available, or alternatively, a recording of this webinar?
Okay. Well, I was going to cover that in our concluding remarks here. So, yes, the presentation will be available on the website. That'll be up there today. It will be followed by the recording of this session that will be up there following that. We may even be fortunate enough to see that today. Also, just want to draw your attention to the second CPD. Although I should probably, before I go into that, Richard, I should ask, is there any other question? Sorry,
No.
I shouldn't just assume.
No, that was the last one.
Okay. So second CPD code word for today is disclosure. The survey is at the bottom of the web page. There's a button there. Please let us know your thoughts on it. The button's there for completing the survey and entering the CPD word. But please let us know your thoughts on everything. We really appreciate getting your feedback. Contact info. Please let us know if there's anything we can help you with. Always happy to help. And if you have any questions or concerns or comments following this, please let us know. ASC.ca. Also in the slide deck at the end, you will see our contact information. So hopefully that covers everything. So we will conclude. Thank you very much, and we will see you again.